Be welcome. I'm Professor Manuel David Maceno from the Polytechnic of Beja in southern Portugal, where I have a teaching role in cybercrime. And this time, we'll take care of the criminalization of attacks against networks and information systems in European Union law. First, we'll see the problems to be addressed by these laws, then the previous legal instrument used by the European Union to deal with them, the new legal and political context that made the European Union go to another legal instrument, and the legal instrument, the 2013 directive. Problems to be addressed. Well, more than any other criminal subject, and I might be positive about this, there is a need of international or supranational references for the different laws and jurisdictions, meaning that in the world, and the world now is interconnected by networks that allow anyone, anywhere, to have access by cable, by Wi-Fi, by satellite, by any of a great range of technologies to internet. And that same person might be at a territory with or without laws regarding cybercrime, or sometimes with laws on cybercrime that are so different from other laws that that difference lets those persons that would be criminals according to some given laws to not be criminals against or in relation to others. Besides, law enforcement and judicial systems are in general not used to cooperate or do it with reserves. And being cybercrime a worldwide menace, common grounds, either in law or in jurisdiction law enforcement, are very necessary. Well, and for instance, dialogue. Law enforcement agencies sometimes communicate informally, but that's not enough. What was the first and most relevant worldwide attempt to overcome this problem? The Council of Europe Convention on Cybercrime, signed at Budapest, the 23rd November 2001. This convention intended to overcome the problems put by the principles of legality and territoriality that come together in criminal law. Besides, it seems to be an European convention. However, since at the United Nations level, there is no body that could deal with the subject, the Council of Europe, that had references from the late 80s, put in action a procedure for an international instrument. A quite international one, in the sense that from the beginning, the United States of America, Canada, Japan, and South Africa, meaning the most technologically and economically advanced countries of each of the continents, joined the European members of the Council of Europe. And I remember you that the Council of Europe reaches from Iceland to the Far East, since the Federation of Russia is a member state, as well as Turkey, for instance. But these countries join forces with the European countries in order to achieve a common ground in order to fight against cybercrime. This convention has 3 parts, and it's a decision of putting together substantive criminal law, the offenses, procedural law regarding even crime investigation and crime defense guarantees, and also a third part focused on cooperation between law enforcement agencies and judicial systems. This convention is in force since 2004, being the last countries to ratify it, last since 2012, Austria, Belgium, Malta, Georgia, Switzerland, Australia, the Dominican Republic, and Mauritius, and the last one, in the beginning of 2013, Panama. As you can see, this convention reaches much part of the world, well beyond European borders. Now, you'll be able to answer why national approaches, I would say purely national approaches, are not adequate or enough for fighting cybercrime. Meaning, a global menace needs to be confronted with a global system, global criteria. Well, next subject, a previous legal instrument. Exactly the Council Framework Decision 2005-222 GHA of 24 February 2005 on attacks against information systems. But why did the European Union had to go on adopting such instrument? Would not the Convention of Budapest be enough? And the answer would be yes, it would be. However, some of the member countries did not agree with all the contents of the Budapest Convention, and by 2005 did not ratify it. Just remember that before I mentioned that Austria, Belgium, Malta, and a few months before, the UK ratified. Even now, by now I mean 2014, Greece, Ireland, Luxembourg, Poland or Sweden have not, and it's not foreseeable that it might happen. For instance, the Czech Republic did it last December 2013. So, the European Union had to come across with a sort of plan B, meaning that going to the Convention of Budapest, identify the subjects, the issues where a consensus might be achieved within the European Union, and put forward an European instrument. At this time, before the Treaty of Lisbon, criminal matters were outside the scope of the European Union. Well, in the sense that in the third pillar of judicial and police cooperation in criminal matters, they could be addressed, but in a purely intergovernmental way, meaning through unanimity. It's based on the former Articles 34 2b, 29, 30, 31 of the Treaty of the European Union. And the objectives were to put together those common criteria essential for fighting cybercrime, if not on a global level, at least within the boundaries of the European Union, having a common reference for law in material law, but also putting in place a system of interchange of information and cooperation between law enforcement agencies. What were then the main contents? You had here offenses, just 3, illegal access to computer systems, illegal system interference, and illegal data interference. Later, we'll see each of them, since they are now within the framework of the new directive. Now, you will be able to answer, after watching this lesson and all the materials that are linked at the university page. We'll find all of them, be able to answer what issues had to be urgently addressed by the Council framework decision. Now, we have to address the new legal and political contexts. First, now we have the explicit inclusion of criminal law in EU law by the Treaty of Lisbon. Well, now, with Article 83 of the Treaty for Functioning of the European Union, the Union has criminal competencies. There are a few precedents, some implicit and other explicit and controversial, meaning directives of 91 on money laundering or 2002 on unauthorized entry, transit, and residence of persons, to the directive of 2000 and foreign protection of environment through criminal law, and very, very controversial decision from the European Union Court of Justice of 2005, but meaning that criminal law slowly enter within the core of the European Union law. Following criminal policy statements, after the entry into force of the Treaty of Lisbon, the European Union had a new objective: deal with a common space of liberty and justice, much more than just the pillar from Maastricht. So we have the Stockholm Programme of 2010. In full, an open and sure Europe serving and protecting citizens. You have already studied it. Now, I just need to add that a main concern within the Stockholm Programme that will last till this year is cross-border cybercrime. Then, the European Commission came across with two communications stating its view of the future, one of 2011 and the second of 2012. The first of them, named towards an EU criminal policy ensuring the effective implementation of EU policies through criminal law of September 2011, this puts in place, and it's important for us, the main principles regarding criminal law. Principles that were already part of the common core of member states. Namely, that criminal law will be always the last answer. That criminal law had to have in mind fundamental rights. Everybody has rights, even criminals, and this might never be forgotten. And always the paramount principle of proportionality. The second communication, tackling crime in our digital age, establishing an European cybercrime center. This is a communication by the end of March 2012, puts the priorities of fighting crime within the information society, the network society. For our sake, for the purpose of this lesson, I would underline the objectives of fighting organized crime, not kids that pretend to be hackers, and also protecting, and there is a close link with cybersecurity, protecting critical infrastructures. Besides, this communication presented a new European cybercrime center to function side by side with Europol in The Hague. This center is already at work since January 2013, and you will find a link towards its web page at the university, your university platform. So now we'll be able to answer the question I assigned you. What's the intended role of the European Union regarding cybercrime. The 2013 directive, in full, the directive 2013-40 EU of the European Parliament and of the Council of 12 August 2013 on attacks against information systems and replacing Council framework decision, the one I addressed before. Well, reasons for adoption. Why was not the framework decision enough? Well, besides legal reasons that we'll address immediately, the problem is in the new technology. The European Commission showed to be very concerned regarding botnets. For botnets, we mean networks of computers hacked and controlled from the outside, meaning that many of you, I'm sure, have within your systems malware that you receive by email, by on website, computer programs that are inside your systems. You have, well, you do not need to go away from the computer now, but in the sense that possibly a share amount of you have infected computers. Those computers will not harm you. They are not intended to get even the information you have within it, but when needed, namely when you are asleep, those computers will be activated from the outside and put to work together from a center. So instead of having attacks from a few computers, attacks namely to critical infrastructures or to European or national institutions, there will be thousands of computers attacking at the same time. And for computing, now with so-called Internet of Things, even refrigerators connected to the Internet are used as points of reference, of replication for botnet attacks. So this was the main reason for the European Commission to come across with the proposal. The idea that now we are within a fully networked society and law has to keep pace very fast way. Just to say that, remember that the time before the adoption of the framework decision and the presentation of the proposal was very short, unusually short for what is usual or normal in law. Legal base, after Lisbon, the base is the treaty for the functioning of European Union, namely Articles 82 and 83 that allow the adoption of directives intended to become part of each member state legal order through transposition. The treaty, for the moment, does not allow the adoption of regulations. The option for a minimum harmonization directive. Well, it's quite understandable. Criminal law is a very, very, very sensitive point of law and national policies in general. So sensitive that till the Treaty of Lisbon, member states avoid to let the European Union have this tool in hand. We've already seen that there are few exceptions that even without this permission, and even going farther than would be fair due to the principle of conferral, we had these criminal answers. But now, the Union might do it. However, a wide margin of freedom is left to member states. So, this is the minimum. And it's important to take a look at Article 1 and please pick the directive and have it in hand. But this Article 1 states clearly this is a minimum. Each member state can go farther. No, not less, but more. And I emphasize this because if you take a look at each provision in itself, you might even think that the content of the rule is not so strong, does not go so far as it happened with the framework decision. But see, this is a minimum. It's not a full harmonization. The offenses. Here we have, and we'll go from now, from provision to provision, please, for your own sake, have in hand the directive. Just click on the link or print it. It's up to you, but have it in front of you. Now we'll deal with the first offense. Illegal access to information systems. We'll take care of the contents and the protected good. Well, member states shall take the necessary measures to ensure that when committed intentionally, and this has to do with a specific intention, if the access is done for the sake of research, of sake of criminal investigation, but without a criminal intent, it will be not an offense. The access without right, in general, without the permission of the person in charge of the system, or the permission of a judicial or administrative authority, the access without right to the whole or any part of an information system is punishable as a criminal offense when committed by infringing a security measure, at least 4 cases which are not minor. Meaning, if a kid enters into an information system just for kidding, if a youngster does it, it's part of, well, being a teenager. Member states are not compelled to punish that person. It's more important what seems to be new. At least, and I remember the connection between Article 1, minimum harmonization, and this Article 3. At least member states will punish if the access happened or was possible through the infraction of a security measure. If the system has no security measures, member states are not compelled to, but might not punish. What is, in this case, the protected good? I would not say property, because there is no necessarily a property right regarding the contents or the system. I'll stay in a more conservative way with the integrity and the availability of the system. And that allows the person in charge, the owner, to exclude everybody else. Then we have illegal system interference. Again, we'll take a look at the contents and the protected good. The Article 4 states, member states shall take necessary measures to assure that serious hindering or interrupting the functioning of an information system by putting computer data, by transmitting, damaging, deleting, deteriorating, altering, or suppressing such data, or by rendering such data inaccessible, intentionally and without right, is punishable as a criminal offense, at least 4 cases which are not minor. Well, let's put aside this last part. It's the same as in the previous offense. Here, we have more than access. It also deals with the protected good of availability of the system or the part of the system. In general, someone gets into the system and disturbs its functioning, hinders data, encrypts it, put inside a worm, a computer worm, and the system will not be fully available to you. Even if it's available, it will deliver so slowly that it would be materially unavailable. But it's not just for any felon getting in. If someone from the outside, namely through a botnet, attacks a system and prevents the system from working for so many inputs, and you have a denial of response, that's also an illegal system interference. Going on, we have now illegal data interference. Contents protected good. According to Article 5, member states shall take necessary measures to ensure that deleting, damaging, deteriorating, altering, or suppressing computer data on an information system or rendering such data inaccessible, again, intentionally and without right, remember it has to do with specific intent, is punishable as a criminal offense, at least for cases which are not minor. In this case, more than the availability of the system or even the data, the protected good is property. The right on that data. That data that might be destroyed or damaged or prevented to be useful to the owner of the system. Then we have illegal interception. Again, we'll see a bit of the contents and the protected good. In this case, and going back to the text, member states shall take necessary measures to ensure that interception by technical means of non-public transmission of computer data to, from, or within an information society including electromagnetic emissions from an information system carrying such computer data, intentionally and without right, is punishable as a criminal offense, at least for cases which are not minor. In this, what we have here is trying to get, not in the system itself, but to data that flows from the outside to the system by cable or by Wi-Fi, or from the system to the outside. We are in networks. When a computer communicates with another, it will be, and is now, a criminal offense to get that information. We have this reference, explicit reference to electromagnetic emissions. Well, from the outside, and it seems that the NSA from the United States did it, you can analyze the way the computer worked in order to get signals regarding the content of it. But for a more plain, normal example, most of you possibly have Bluetooth in your cell phones. If someone gets information from your Bluetooth device intentionally and without right, that person would be under a criminal offense of illegal interception. Here, again, the main good protected is property over content. Then, well, tools used for committing offenses, contents and protected good. What we have is not just having in hand computers, botnets, passwords, logs, would be part of another crime, but developing them and having them available is already a crime. Well, member states shall take necessary measures to ensure that intentional production for criminal objectives, sale, procurement for use, import, distribution, or otherwise making available of one of the following tools without right and with the intention used to commit any of the offenses is punishable as a criminal offense, naming a computer program, but also computer password, access code, or similar data. Besides that, we have rules regarding incitement, aiding, abetting, and attempt. All will be punishable. I just want you to pay attention that regarding attempt, all these crimes or these offenses will be criminally persecuted. It's when just an attempt, but the illegal access to information systems. Well, penalties, according to Article 9, they will have to be effective, proportionate, and dissuasive. And sometimes the idea is from 2 to 3 years, but you'll see by yourselves the details. Legal persons, besides physical persons, will be liable. It's a given aspect. If a company gets a profit from crime, that profit has to be, or has to lead to a criminal persecution. Some critical issues. First, attempts of illegal access. Just remember that unlike the framework decision with the directive, this attempt of illegal access in itself, it's not compulsory for member states to put it as a criminal offense. Device and botnets. Again, botnets seem to be the main concern of the European Commission. However, the use of botnets and other technical devices appear in the directive as a factor for higher penalties, no less. The same with identity theft. Making someone pass by another in order to commit an offense. Again, identity theft is not a criminal offense in itself, but it would be a criterion for higher penalty. Jurisdiction, and here in jurisdiction, we have extension with some options of member states, in the sense that here we have several ways of extending jurisdiction. It doesn't matter where the offense has been committed, if in whole or in part of the territory of a member state, by one of their nationals. Even if the offense is against an information system in their territory that might be persecuted as a criminal offense. Last materials, cooperation between national law enforcement agencies, exchange of information. It's the most important. Law enforcement might not be isolated. So a system of 24 hours a day, 7 days a week is implemented at the European Cybercrime Center. The EC3, the European Cybercrime Center. Now we will be able to answer what political and technical context presided over the adoption of the directive, what issues are addressed by the directive. This lesson is over. Now it's up to you to go on with the acquisition of knowledge. Thank you.